Good afternoon, everybody, or good evening. Welcome at our panel, Transforming GDPR into a Risk-Based Harm Tool alongside specific AI regulation. Before we start, I want to outline a couple of things that it won't take more than a couple of minutes, but first of all, how did we arrive here? How did we come to this topic? Well, actually, we were discussing the scope of the GDPR and a couple of notions that get stretched constantly, namely personal data, controllership, sensitive data. And these questions made us actually think maybe the GDPR could be applied broader as a general European data law. And then we started thinking, but how should we do that? And how could it then become the ideal partner next to the AI Act, for example? How would we deal with a risk-based harm approach then? And this is actually how we arrived at this topic. And today we want to tackle questions regarding legal interoperability, the scope of the GDPR, the concept of risk, the emphasis on privacy self-management, the complex data-driven supply chains. And of course, we have panelists to do that. The first panelist we have here is Professor Dr. Nadia Purtova, who is a professor at Utrecht in Law, Innovation and Technology. And the interesting thing is that she just completed an ERC grant about information-related problems regarding data processing. And there she studies the concept of information and data from information studies and economics. So quite an interesting perspective for this panel. And she also wrote very interesting articles about the broad scope of personal data. And then our second speaker is Dr. Felix Pieker. He is actually a researcher at the Data Protection Authority of Schleswig-Holstein, one of the 16 German federal states, if I'm not mistaken. 18, okay. And he wrote his dissertation about the right to data protection, namely that it has two dimensions, an individual one and a structural one. And apparently, most of all, this structural one, focusing on democratic society, will be very interesting for this panel. And then last but not least, to spice things a bit up, we invited Christina Michelakaki. She is admitted to the bar in Thessaloniki, and she is a policy counsel at the Future of Privacy Forum. She studies all the developments at European institutions daily. So her opinion will be very interesting when we talk about legal interoperability. And her research interests, if I'm not mistaken, are AI and fundamental rights. So the perfect fit for this panel. And before we start with the panel, very briefly, we won't have a kind of hierarchical structure. Rather, we wanted to make it a bit more interactive, a bit more provocative. So we prepared a couple of statements, and we hope that the panelists feel so provoked that they feel immediately the urge to reply to the statements. We will first start with a bit of a lighter statement, a bit of a shorter discussion, and then we will slowly dive into the bigger discussions. And I will project the statements normally, if everything goes fine, on the screen behind me. Perfect. And so the first statement we came up with is achieving legal interoperability is challenging given the present flood of EU laws. And actually, I thought long and hard about who to give the floor first, but since it's interactive, you may decide for yourself who wants to take the floor first.
Is it politeness or throwing a hot potato? Well, I agree with the statement. Indeed, there is so much new digital law, which will also be applicable in the situations where the GDPR is applicable. There are bound to be frictions. There are different and new categories of the actors who have the obligations according to those new digital laws. There are obligations in relation to data, which in many contexts will be personal, and sometimes those obligations according to the GDPR and those digital laws might contradict each other, or there might be some miscommunication about the lawful grounds of processing of personal data in while complying with the obligations under the new laws. And to be perfectly honest, I have not been following the development of all those laws closely enough to basically come up with a list of possible frictions. So certainly there will be frictions. At the same time, pragmatically speaking, those new laws will also give us new tools to play with to achieve some protective goals that we couldn't achieve so easily perhaps under the GDPR. So for instance, or even under the newly adopted AI Act. For instance, a couple of years ago, Philip Hacker and colleagues have published a paper on how the Digital Markets Act can be actually helpful, even more so than the AI Act, in achieving the fairness of machine learning models. So that was a new piece of knowledge for me. So yes, theoretically, there are not all, let's say there are a lot of wrinkles to be ironed out. But I think the major, a bigger sort of problem of interoperability, which is perhaps a little bit more on a principle level, is that now all these new laws regulate sort of the same thing, data, in particular personal data, or automated processing of personal data for different reasons, let's say. And it is irrational to think that we will, that all those reasons will be achieved equally well, let's say, by applying the same set of rules, the same set of rules of the game. So for me, I mean, let's be pragmatic, we will iron out those frictions between the new laws and the GDPR somehow. But why are we jumping through all those hoops? Let's say, what is the ultimate goal of all this new legislation? I think this is for perhaps a bigger fish to fry.
Maybe Christina, I heard the word friction and the ultimate goal. Maybe you want to dive into that a bit deeper?
Yes. So first of all, thank you so much for having me here and all of you for being here at 7:30. No, 5:30. And to make it a bit more interesting, I will react to these statements with a first reaction, like an instant reaction, what I'm instantly thinking when I'm reading this, and then what I'm thinking after considering more factors. So when I'm reading this statement, I'm thinking, of course, of all the acts, the DA, DA, DMA, DSA, European Health Data Space, the AI Act, and of course, you have heard already, I'm sure, how are we going to enforce all these acts in practice. And it's true that every time that I open the text of one of these legal acts, I come across a theoretical still issue. For example, with the European Health Data Space, if we have a breach of non-anonymized data, the Health Data Access Body will be responsible to impose a fine, to initiate an action. And we can, of course, understand that since non-anonymized data are personal data, a data protection authority will also be responsible to initiate an action. How are we going to see these parallel actions going on? And the European Health Data Space has some provisions on how the authorities can cooperate, but they're not that detailed. So yes, about legal interoperability, this is my issue. How are we going to enforce it, and how are we going to deal with parallel actions? Now, that's the instant reaction. After giving it a second thought, I'm also thinking about the pace of these acts, because I don't know if you've seen about it, but for example, Italy has now drafted a new AI law. And even though it has a lot of elements that are similar or the same to the AI Act, like regarding accountability and transparency, they also have some provisions that are more specific, I think, considering healthcare and employment. And by the moment that the AI Act will start kicking in officially all its provisions, maybe we will already have other national legislation applying. So the pace is also something to consider as an issue here when it comes to legal interoperability. Of course, this is a bit unavoidable. Technological developments always move faster than legislators can move. So I think also in line of what you mentioned, we should keep in mind what is already here. So we have the GDPR, we shouldn't go to other directions and creating these frictions. The only way to do it, like we can analyze that for hours, but as a general direction is to pay very close attention to the details. Yes, that's, I cannot elaborate more, I think. I don't have the time.
Thank you. Maybe very briefly before we go to the next statement, I heard the word cooperation. I don't know if you want to add something about cooperation or the pace, Felix.
Sure, thanks. This is going to be a quick statement because I don't have an issue with the pace so much. I see, there's a lot coming in right now. What I would have preferred would have been consistency throughout all those things. That they consistently refer to concepts and implement them properly. That would have been really nice, but we have a lot of different things in very many laws, and that just makes it very complicated. We also, of course, need consistency in enforcement, which is going to be challenging with all the new bodies that are going to be introduced, because we know that these bodies will have first to be built up. That will take time. They're not going to hit the ground running, right? We've seen it under the GDPR with the supervisory authorities. We've seen a huge rush of professionalization over the last years with the EDPB and the level of cooperation just being so much higher than it used to be. So I'm hopeful it can be done, but it will take some time. And we'll also have to see with some of the acts how they're being implemented on the national level, because there's still a lot of things up for grabs, and it's not assured how the national legislators, what kind of interests they have and how they will place the responsibilities, whether it's going to be the data protection authorities or whether it's going to be other national authorities enforcing parts of the AI Act, for instance. So I think consistency would have been great in the law. I think we'll have to be sure that the enforcement agencies are in a position to then create it after the fact, at least.
Thank you. I hear the word consistency, and actually this brings us to our second statement. This perfectly aligns, because the second statement is it does not make sense to still use objectively defined categories or defined categories, of personal and sensitive data in the GDPR. And in that sense, we see that these notions, these categories get stretched and maybe pressure the notion of consistency. And I think the perfect person to start a discussion about this statement is Nadia, because you wrote interesting papers about the broad scope of personal data. You even considered code to be potential personal data. So what is your stance on this statement?
Now, whether or not something makes sense depends on why you do it, right? So the nature of the data protection law, if you look at the provisions of the GDPR that sort of suggest what the objective of the GDPR is, the range of objectives is very broad. In the GDPR itself, it says it aims to protect natural persons, fundamental rights and freedoms in relation to the processing of personal data. Then in a number of other provisions, there is a reference to the protection of rights, freedoms, and interests of the data subjects. So basically, and those rights, freedoms, and interests are basically a huge catalog of not only rights, but also, an interest to pay a lower price for a product is in principle also an interest that can be protected by the GDPR. If you look at the literature that's sort of on the theory of informational privacy and data protection, what those sort of areas of law are for. Now, you will generate a very long catalog of all the objectives that in principle those areas of law should serve, from protecting privacy as a sort of right to be let alone and to be secluded from the rest of the world, beginning from that more conventional idea of privacy, up to protection of democracy and presumption of innocence, but also all other fundamental rights, including non-discrimination and what have you. So the data protection law aims to achieve all the purposes one can achieve by regulating processing of personal data. Now, from that perspective, it does not make sense to regulate a certain type or automated processing of certain type of data to achieve all those purposes. In the sense that now, if we look at the origins of the data protection law and earlier informational privacy, if we look at the 60s and 70s and 80s, and for instance, the emergence of these fair information principles. Now, those principles were drafted based on a certain idea about how basically individuals are harmed, as a result of automated processing of information. And that idea was that now there were files about people, and the shift that the computing introduced was that those files were searchable very quickly, that you could look up any record that was made about a person 50 years ago and make decisions about that person based on those records. So this is to some extent still an accurate picture how some of those sort of problems related to processing of information occur. And in that regard, it still makes sense to talk, for instance, about the categories of information. Let's say information about people. Let's say, in fact, we still, let's say, our understanding of privacy in a more conventional way is very tightly related to certain types of information, something that we think belongs in our private sphere, however you define that, because there are multiple ways to do that as well. But because the data protection law for a long time was the only law sort of that did something in the digital context, it gradually, in my opinion, got stretched indeed to be this proverbial jack of all trades that now you can apply in a variety of other contexts. And in many of those contexts, it does not matter anymore what kind of data is processed. Perhaps it's very important, and that's why I also mentioned the rationales of data protection law. So perhaps if the rationales are, for instance, to address manipulation or to protect some consumer rights by ensuring data portability, perhaps these kind of protections do not necessarily have to hang on that notion of personal data, because what you risk to achieve as a result is that the attention, as it often happens now, in fact, will be focused on whether or not it is personal data that is processed, whether or not an individual there is identified or identifiable, whether or not something is in fact information or data. So I will remind you of, for instance, a paper by Michael Will and Lillian Edwards on whether or not machine learning models are personal data. Now, it will keep our attention on that ball while which will serve as a distraction from the actual problem of, recommender systems. Recommender systems present certain problems. And in principle, it will, the fact that those problems exist would not change depending on whether or not the data that feeds those recommender systems, if we define it as personal data, let's put it this way. this way. So that's my position on this. So a short answer, sometimes, but in very narrow contexts, such as traditional privacy, non-algorithmic discrimination, of course it matters which categories of data are processed, and some categories of data need specific protection. In more sort of algorithmic contexts, when the content of data, the meaning of data to people doesn't really matter anymore. I don't think it makes sense to hang legal protection on certain categorizations of data, be it personal, sensitive, or any other.
Thank you for that elaborate and interesting answer. Maybe before we move to the next statement, I heard that there are so many purposes to be achieved, and in narrow contexts, it might still make sense to have these categories. And then I automatically think about the research or the thesis of Felix, because there you say there is a dualistic approach. There is an individual dimension of data protection, a structural dimension of data protection. And do you think this aligns with the answer of Nadia, that, for example, in individual contexts, there is a more narrow context, so it might still make sense, and in these broader contexts, it does not make sense anymore? What is your stance on this?
I think this is where we differ. I think if I look at the rationale of data protection, for me it makes perfect sense. It's always about what you're trying to do, to have a wide scope of personal data, because data protection ultimately is a gateway, right? Just think about all the things that you do on your phone. Think about what kinds of rights you're exercising. Think about what kinds of rights could be affected. All of that goes into a data processing device. So all of this is data that's being processed. So this is why we want to look into it. Given the theme of the conference, if you think about AI and all the things that it's being applied to, it makes sense that we look into everything, because there's always going to be risks, and there's always going to be relevant rights that will be affected, because it pretty much affects all of your life. There are very different genealogies. I think that's important to remember, of privacy and data protection. And if you have the chance, read Gloria Gonzalez-Fuster's thesis on it, which gives you a really good overview of how it happened to come across in the EU specifically. And I agree that privacy has always been a bit fuzzy. I think, and this is what I'm doing in my book, is I think there's a pretty clear genealogy of data protection always having been the structural element as well, always having been about defending democracy, also fighting against discrimination. Because if you think about how it came to be, especially in the German context, that the German debate on data protection obviously was defined and inspired by the Nazi era, and how the processing of data led to the attempt to exterminate a people. And this is something that made it very clear to the people discussing it that we would have to be sure that marginalized people would be protected as well by data protection. So there is this clear genealogy of it also being structural. I'm not a big fan of sensitive data, because I think that, much like the Federal Constitutional Court has once ruled, all data are potentially relevant. It depends on the context that we're talking about, right? My location data here is probably relatively innocuous. If, a woman goes to an abortion clinic in the United States, that's very different. So I would have trouble saying, oh, location data is sensitive or not, because, well, I don't know, depends. So I think all data is relevant. I also think that we definitely need to be looking more into, because Nadia was talking about algorithmic processing and algorithmic systems. And I think there's a big issue that we haven't covered yet in the law, which is group rights. Because I no longer need to have your data to discriminate against you. I can just group you with a bunch of other people, infer data about them, and then discriminate you based on that. That's great, but then as an individual, it's hard for me to do anything, right? And it's hard for the individual in general to do anything, because people are usually kind of, trying to make a living as well. They have jobs. They don't have time to run to the data protection authority all the time. So we needed to kind of work out of the box. And that's why I think it would be really important to do more with group rights, so that the collective has more range to assess, so that it isn't always on the individual, aside from the structural, which is still there. So we don't need to pitch them against one another. We can just have both. And when it comes to predefining some categories or certain risks or certain harms, I'm very cautious, because these things get dated really fast, right? We just suddenly have a new technology, new kinds of risks. We're going to have to wait for the legislator every time to come in. So I see some risks there, and I think we'll not be getting. And I've been observing this in a couple of new legislations right now, in the AI Act and the Platform Workers Directive. We never get the prohibitions that we need in a given moment, and that'll always affect mostly marginalized people first. And probably also heaviest. We've seen that with regard to surveillance. We've seen it especially at the borders and with law enforcement exceptions. So I'm not very hopeful that the legislator there would actually care to legislate anything.
Thank you for that answer. We had the discussion whether it makes or still doesn't make sense to have these categories. But another discussion that is related to that is the fact that our current thinking about the broader risks of data processing. You mentioned we should be very careful with really defining certain risks. But we could say our current thinking about the broader risks of data processing and the use of AI and its long-term impact are limited at the moment. And criticism that we hear in this regard sometimes is that, for example, our thinking about discrimination, non-discriminations is mainly based on offline identifiers, while we haven't had the chance yet, or we are not able yet to fully map all discrimination dangers based on online identifiers. And for that one, I want to start the discussion with Christina. What is your take on this statement?
Yes, so if I understand correctly, it's also a bit a statement that criticizes on the risk-based approaches. And I think my instant reaction, and it's also the second reaction, it's one reaction, it's that I'm a bit skeptical on rejecting risk-based theories. That would create, for sure, a laissez-faire environment for entities, and we will lose accountability mechanisms. But I'm very much in favor of making them work, making risk-based theories work. And here, I want to build a bit on arguments that Mirai Hildebrand and Katerina Demetriou have put forward. But I will also use some conclusions that I've reached in a report that I co-authored for Article 25 GDPR. So let's take the example of the GDPR. Hildebrand and Demetriou are arguing that we should understand the risk as being a risk to a right, rather a risk to a harm. And this is because if we ask to see harm, we are basically diminishing the protection of the fundamental right to data protection. If we don't ask to see harm, we are adopting a more preventive approach. And now if you see that in a more practical context, using my the report, we can take the case of Austria. So we had a citizen that complained that a public repository did not implement sufficient security measures, and therefore, in the hypothetical case of a data leak, his right to secrecy would be violated. But we didn't have a data leak yet. And the Austrian DPA said that since we didn't have a data leak yet, the data subject only have a subjective legal claim which could not be accepted. The Austrian DPA asked to see some sort of harm. It also asked to see the violation of another article of the GDPR. That's not the only approach. We have other DPAs that say that Article 25 GDPR can be applied on its own. And I can also remind Article 25 GDPR, it's about data protection by design. So the controller has to implement all data protection principles and all data subjects' rights by design, so before the processing. And it sounds pretty preventive. So that all is to say, before rejecting a risk-based theory, we actually need to understand what exactly, how we want to use the risk-based theory, how we envision using a risk-based theory. And that's also very important in the context of the AI Act and how we use risks there. And I'm sure you've already heard about this, but very briefly, in the AI Act, we have Article 3 that says that defines risk as the combination of the probability of an occurrence of a harm and the severity of that harm. So it has the notion of harm there. And of course, how a law is going to be applied is it's to be seen on the interpretation. But yes, I'm skeptical of rejecting a risk-based theory. I'm more in favor on working a bit more on how we want it to work.
Thank you. Felix, I saw you nodding a lot. And actually, this morning or this afternoon, I heard Mireille Hildebrand, and she also said, like, okay, risk in terms of the GDPR is a risk to an interference with fundamental rights, but on the other hand, a harm could also be like a sort of example of a risk that could potentially occur. And in that sense, do you have something to add to what Christina just said, or do you have something to add about our conception of broader risks that might differ depending on the legislation?
Yeah, sure. And I think the point that Mireille is making is very interesting. But as Christina already said, we have risks in the law, so from a DPA kind of point of view, that's what we're enforcing. But of course, we also have harms when it comes to assessing risk that could be materializing. So I think from the legal perspective, we can focus on that. I think Mireille does some very interesting work on that. But of course, then we kind of stray from the legal provisions. And as a DPA, obviously, we can't just do that. I think one of the issues, if we're being honest with finding risks, is that you actually kind of have to search for them. And especially when we're talking about AI, which we're doing at this conference, we're very much stuck at a very basic level for a long time. We've had papers come out 2018 by Abeba Birhane and by Timnit Gebru et al., and the stochastic parrots paper that is what I'm referring to. And they identified risks of AI systems very clearly and very succinctly. And some of the big tech companies still can't find those risks in their operations before they, bring to market their things and start making profits from them. And then we have marginalized people out there who are bearing the consequences of that, not wanting to find risks. So if you actually did want to do a proper assessment, whether that's a DPIA or a fundamental rights impact assessment, I don't really think it matters all that much because those risks are pretty much known. Even if you had a list, which is not what a DPIA is about, but even if you had a list, you could check and you could see because all of this has happened before and it keeps repeating. So this is kind of a bit weird. So you actually just need to carry them out properly. And we also should make sure that it's not always the marginalized people. And you were talking about online identifiers and kind of like the offline groups that historically have been marginalized. It kind of tends to always be the same people, though, whether it's online or offline. We're always talking about race. We're always talking about gender, queer people, the kind of misfits in the systems. And as Mar Hicks has shown, when it comes to trans people, for instance, there's a long history of how data processing was used to marginalize that group. So it started offline, it moved digital, and it's moved online with us. So it's not new. It's not a novel thing. It's not something that we couldn't have foreseen. It's just that we turned the eyes away from it. And I don't really think it's a matter of methodology. or whether you do a DPA or FRA. It's just a matter of priorities.
Thank you. We are tackling the concept of risk at this moment, and interesting because this perfectly brings us to the fourth statement, namely that data processing should be regulated based on harm and risk theories that apply across the GDPR and the AI Act. And the interesting thing to discuss there would be, how do we find, or can we find, synergies between risk in the GDPR and risk in the AI Act? Because one could say that the AI Act more or less originates more from a product safety law perspective, and the GDPR from a fundamental rights approach. So can we search for synergies between the concept of risk, and how can we do that actually? And I would like to ask that question first to you, Nadia.
Thank you, Michiel. Both concepts of harm and risk are highly laden concepts. Whenever, for instance, whenever somebody uses the term harm, and let's say, I mean, there are a number of synonyms of the term, which also, among others, include sort of the so for instance, in the context of my ERC project, I first was talking about how to recreate or redesign a system of legal protection against information-induced harms. And within certain communities, the thinking that immediately triggers is that we were arguing for post-factum sort of legal protection, tort-like legal protection. First, the harm has to occur for the legal protection to kick in. While basically, risk is also a very particular concept in a sense that it refers to the likelihood of a particular problem or harm materializing. I think perhaps one has a higher chance to find some synergies between the GDPR and the AI Act if you operate with broader concepts which don't have this sort of baggage, let's put it this way. So for me, the first, the departing point of any regulation is to establish what goals you want to achieve with that regulation. And clearly, some goals of the GDPR and of the AI Act overlap. For instance, protection of the fundamental rights of natural persons. And then, depending on, let's put it this way, the term that I now prefer to use instead of the harms is sort of a digital wrongs, sort of what problems do you want to avoid by means of the regulation. And so, for instance, one of the problems that we sort of distinguished was, the problems associated with the use of computing. And that the computing can come in various forms, which are, not autonomous at all, or with varying degrees of autonomy. And so, and looking at the history of data protection law, a lot of it, let's say, its evolution sort of coincided with the evolution of computing. So perhaps some of the problems where there is clear sort of reinforcement, mutual reinforcement between the GDPR and the AI Act is to tame the sort of the problems associated with the use of computing. Now, I think that in that paper you referred to, where we argued that computer code under some circumstances can be personal data, we explored basically what applying the GDPR principles to computer code would mean. And we actually arrived to the conclusion that now the consequences of applying the GDPR to computer code are not absurd at all, let's say, and some of those principles would deliver a higher level of protection, let's say, even compared to what the AI Act is currently doing. So, for instance, thinking about the principle of purpose limitation, it could translate into a requirement that computer code developed for one context should not be reused for another context, let's say, which is not compatible with the original. So it's a little thought experiment. Let's say, yeah. So for me, let's say, focusing on risks and harms, it's a little bit misleading because it immediately triggers certain, let's say, yeah, it invokes certain meanings of those terms which we probably do not want to put in them. For me, it makes more sense to think about the problems and the outcomes that we want to achieve with both of those regulatory instruments.
Thank you for that answer. In this afternoon in the conference, I heard in a panel people saying AI is actually just another hurdle to take for data protection. And I heard another person say, rarely there is a magic line separating data protection issues in AI from those in the digital age. I heard you say that there is overlap in the goals. And I would like to ask Christina then, how do you see this overlap? How do you see potential synergies? What is your stance on the concept of risk and harm? Does it make more sense to look at the broader goals? Yeah.
Yes, I don't know what to comment first on that. So I heard the word overlap. So to the extent that the AI Act projects that it protects the fundamental right to data protection and the GDPR protects the fundamental right to data protection, there is not an overlap in a certain degree. For me, it's very important to see how the acts complement one the other. And that's very important, first of all, to see the value in the newest act, at least from the perspective of data protection, right? Because, of course, the AI Act is, in a sense, broader than the GDPR because it also protects other things, not only data protection, of course. And it's also important because in that way we will basically understand the obligations that all the actors may have through the different acts. So it is an overlap, but it's not that it's not necessary as well from a data protection perspective. I think the AI Act kind of complements the GDPR in many ways. So one of these ways is, for example, capturing the provider as well, something that the GDPR does not do. In the recital concerning data protection by design, tries to do it, but it doesn't do it in the main articles, which is very interesting. So now with the AI Act, because the roles of the controller and the processor are not exactly, you cannot just track them in the AI Act easily. Maybe in some cases the provider will need to have some roles that would normally have under the GDPR, some responsibilities, I'm sorry. So in that way, it's a desirable overlap in terms of data protection, I would say. So yes, I mean, I don't want to go on again on the exact statement, but I agree with what you already stated. And I think that it's basically understanding what the acts want to protect. And when you are projecting that you are protecting a certain right, you definitely need to move towards that direction, whatever that may mean in practice, either focusing on the right translation of a risk-based theory or the right translation of a harm-based theory, which links to what I was referring to before.
Thank you. I heard a couple of interesting things in these answers. Namely, first we talked in the panel about protecting broader interests, about the structural dimension, and about the desirable overlap. And actually this brings us to our next statement, because I heard Nadia say, for example, we could apply purpose more broadly to computing, and in that sense, we could say that we need a general data law that makes certain principles, like purpose limitation, regarding data processing more universal. And I would like to ask the opinion of Felix on this statement. Do you think we need this, or you don't agree at all? Do you think that the concepts in the GDPR, for example, purpose limitation, are universal enough to be applied in multiple contexts or not? And how far can we go with the GDPR? What side effects can we tackle?
Yeah, you kind of almost took a little bit away from my point, but that's okay. I mean, yeah, I think a general data law would be interesting and good to have. I think we could call it something like general data protection regulation. I mean, the thing is, personal data has a very broad scope. That's intentional. And therefore, we have a lot of stuff that falls under the GDPR, and that's a good thing. Now, the GDPR isn't perfect. It's leaving out a lot of things, but especially when I'm thinking about AI and the AI Act, in there I see a lot of things that I struggle with that are being allowed, and that actually under the GDPR would have been much more problematic to argue that they could have been allowed. So I think, while I agree with your points about the providers and all that being included, that's great. I would just love to see that also in that lofty general data law that we're doing. And I think when it comes to the harms, if we actually stick to the definition, and that is very wide, so the example for not personal data that I can think of usually is something like, the weather in Brussels on this date was rainy. That's not personal data, right? And I don't see a lot of risks for that. So I'm perfectly fine with people doing whatever they want with that kind of data. I don't have a particular need for regulating that. I'm sure you can come up with some sinister things, so maybe other people want to think about it, and I'm all for that. But as far as I'm concerned, it'll be difficult enough to do anything really nefarious that I don't really think it's my priority. Now, the Data Act kind of does venture into this whole thing a little, unfortunately, I think, and I think it would have been better if they had not done that. Fortunately, how they decided with the privacy regulation, I think there would have also been more and less in this regard. Now, the question is, could we reform the GDPR, which I'd have a couple of suggestions for, but I also worry about the lobbying that we've seen with the GDPR already, that we've seen with the AI Act. I think it even intensified, if that was possible, and that gave a lot of sway to industry. So I think, for my purposes, I could perfectly fine work with GDPR, be happy about that, and just make it work. Because we have the risk-based approach, and I think we need to be careful about how we're talking about risk-based approaches, because risk-based approaches aren't an end in themselves, right? It's about what kind of risk are we talking about, and in data protection, in the GDPR, we are very consistent about it. We have the risk to the fundamental rights of natural persons. That's a good kind of risk to assess. In the AI Act, I actually kind of counted for fun. And it was in one of the drafts, so it might not be entirely accurate anymore. But depending on how you want to categorize it, you have roughly like 50 certain different kinds of risks. So yeah, it's a lot, and it's not really helpful. I would be fine without that. So yeah, I think in principle we would have something nice that we could use, and it would be nice if we wouldn't start undermining it.
Thank you. Nadia, do you have a different opinion, or do you agree with that?
Yes, I do have a different opinion. I think Felix knows that. We've talked about that earlier. So I do not disagree, Felix, with what you say. The GDPR gives us a very useful set of tools that we can use now to address a broad range of, let's say, the dark digital arts, let's put it this way. But I think there are two problems with the legal regime of protection hinging on the concept of personal data. Now, in theory, if you follow the case law of the Court of Justice, personal data is really a very broad concept. Let's say So the weather in Berlin is such and such, at some point can also become personal data when it, when it is used, for instance, in decision-making about a particular person, right? If the GDPR is applied and enforced in every situation where it applies on paper, I think it's difficult to, or at least I think it's difficult to disagree that it will collapse, in a sense that, well, famously Advocate General Bobek said that GDPR is the most disregarded piece of European legislation. Just to illustrate an example, how many of you have looked up somebody online in the course of your professional activity? Now, so you do not fall within, this clearly constitutes processing of personal data of somebody. You do not fall within the household exemption because it's not for in the course of the household activity. Now, Felix, have you gone through looking for a ground of lawful processing before you looked somebody up, and have you informed that somebody about the fact that you looked somebody up?
I mean, there's a couple of legal bases that I could think of, right? It could be a legitimate interest that I'm working on.
Absolutely,
it could be my as a public authority, I could have a legal basis for that. So I don't think it's that difficult to find one for that. And I think there's much to be said for yes, of course, once you introduce more data into non-personal data, it becomes personal data. But I think that's by design. That's supposed to be the case.
But Felix, listen, so it's, let's not direct the question to you. So I personally look up a lot of people very often, and I do not jump through all those hoops. I'm not saying that processing of personal data will be impossible. I'm just saying that complying with the GDPR will take a bigger part of my day. And the same can be, let's say, so on the one hand, the concept of personal data, it covers so much that if indeed, as the GDPR is sort of crafted now, if it equally applies to, a very popular example of a baker, or Netflix and what have you, the data protection authorities will not be able to enforce it. They already do not enforce it. Let's say they go for low-hanging fruit. They normally just impose fines for data security breaches that have been reported to them by controllers themselves. So this is in theory. In practice, because the concept of personal data is so complex and there is so much relevant case law, which not every control is able to follow or understand, the data protection law is not applied in practice as broadly as it should, let's say, and so you have a lot of these digital wrongs falling through the cracks. And so, as I said earlier, this, let's say, hanging the legal protection against the broad range of digital harms on that concept of personal data very often does us a very bad service, in a sense that if a controller, a small to medium-sized business or what have you, decides that he doesn't process personal data, or if, say, big tech company that has so far been disregarded by the data protection authorities in its privacy policy states that they understand personal data in a much narrower sense than, for instance, the legal definition of personal data in data protection law, they do not apply the GDPR as well. All this could have been avoided, say, if the target of regulation was a broader concept than personal data. Now, that, of course, is not without its own problems, as in, if you stretch the scope of protection even broader than personal data, sort of you will get not just the law of everything, but the law of everything on steroids. And for this reason, for instance, what we proposed is a layered sort of system of regulation where this sort of the most basic layer of protection would be general principles of use of computing, for instance, design and use of computing, which are explicated for certain contexts in sectoral legislation. For instance, administrative law definitely needs to be updated for the digital context, so does the consumer protection law and what have you. But So I think we remain, we stay disagreeing with each other.
I think it's very interesting to have two different perspectives in the panel. And for the sake of time and to still leave room for questions from the audience, maybe I will try to combine the last two statements in the sense that I heard Felix talk about group rights and the fact that we really need those group rights. And in that sense, one of the statements we came up with was that the current focus on self-management of data protection is limited considering the evolution of data processing contexts. And there we could also think about data spaces that are actually more collective, open, dynamic environments, more as a collective setting of purposes. And the seventh statement relates to that because the seventh statement could be about collective responsibilities, namely that the increasingly complex data-driven supply chains require a different view of the division of responsibilities under the GDPR. So collective rights, collective responsibilities. What is your opinion on this, Christina?
Yes, so I think for these statements to combine them, I would say that it's important to probably take a step back and understand why we want to place the emphasis somewhere. And even though I don't like the phrase of we should find the right balance, because everyone will agree, it's about finding the right balance, because if you see the GDPR, for example, it doesn't place an emphasis on the provisions on legal basis or the provisions on consent. It wants all the provisions to apply. And in the same way, I think in the context of a data space or in the context of the AI Act or in the context of all these new legislations, we should see robust design approaches, but also individual mechanisms. So that would be, I think, a remark that I can give for both of the statements. And again, as I said before, trying to understand why we want to place the emphasis somewhere. Maybe it's because we didn't looked at all the details in what was failing with taking a risk-based approach or what was failing with taking a more collective management approach. So yeah, that would be it for now.
Thank you. Maybe Felix, because you mentioned group rights, do you have something to add?
Sure. I mean, I wrote an entire book on how I think both is important. I think the structural issues of data practices, and that goes hand in hand with the obligations for controllers, right? That it has to kind of work out of the box. And I think that's very important because if we don't have that, we'll just be running into circles and they are accelerating, right? A lot of the issues that we've seen with how controllers are like, oh, we're not even processing any personal data, and then saying, oh, we might be processing personal data, but actually it's no problem. We have these things here. We've seen all this already play out with social networks, and now it's coming again with AI. And then by the end of it, there's a horde of lawyers that is basically with their teeth defending the business model of that big tech company, and we have to kind of lawyer up as well, but it takes a lot of time, right? I mean, we did actually take on one of the big fish. We did, from little Schleswig-Holstein out, we took on Facebook. We were trying to stop Facebook fan pages. I think it was when it started, I wasn't even working in data protection, I was still studying law. I think it was in 2009. Facebook fan pages were like the thing back then. And you all know the judgment in Wirtschaftsakademie. And when did we get that? That was 2016. And nobody cared really for Facebook fan pages anymore. We had moved on. But that's when we got the results of that action. And then they said, oh, by the way, we've changed everything at this point. So now we're still busy with that, right? We're still busy with those legal proceedings. And as an authority of like, 30 or 40 people, it's kind of difficult to take on 5 of those at the same time, because then you're just binding all your resources, and then all the complaints are going to stack up, and that doesn't really go well under the GDPR for you. So there's a lot of pressures. We're still doing big investigations, by the way, of course. There's also coordination amongst the DPAs. We're we're investigating ChatGPT, for instance. That's one of the big ones right now. There's a lot going on. Again, I don't want to pitch the structural and the individual, because both is important, because I think it's very important that DPAs work on their own and have their own big investigations, because that's easier to tackle the structural issues, right? There's also great work being done. I mean, look at Max Schrems and what they're doing with individual rights. That's getting them really far. Keep in mind, though, that's an NGO. They have a budget. They're very public about it, right? It's great. This is great transparency. But that's not something that just a random person can do with a data subject request, right? That's not doable. That's why they are an organization, and I think an important one. But I don't want to be in a position where I always have to trust the state to, oh yeah, they're going to do the right thing. They're going to think of all the marginalized people. I want always to be able to trigger them and say, hey, my rights are being mistreated here. There's an interference with my rights. So I think that's very important. But I think we mustn't overemphasize it with that neoliberal twist of like, oh, you're being empowered here. No, they're not being empowered. They're getting a huge workload that they can't possibly tackle. So it's important to be able to set the impulse and say, hey, look into that. But it's just as important that they do it on their own.
Thank you. And I think we have more or less 10 minutes left. So maybe very briefly before we open up the floor for further questions. Okay, I see 7 minutes. Nadia, do you have something to add to these 2 last statements and collective responsibilities, collective interests?
I think by regulating computing practices, you would basically address the collective aspect of data processing that Felix mentioned. But getting back to your statement, I think in the current case law on the notion of controllership and this distribution of responsibility, there are sort of windows of opportunity to address those sort of spiders in the net that orchestrate data processing, let's put it this way. So Michael Will, in one of his talks that I heard, for instance, mentioned Jehovah's Witnesses. It is true that a very broad sort of approach to how to determine whether or not an actor has influence over data processing there is very promising, and it's applicable, for instance, to the social networks or other platform providers. So, well, I think so I might have principal objections against how the GDPR is constructed and how viable it is in the long term, and if it's the best way to arrive at certain goals. But speaking practically about now, does it offer us sufficient tools to go after really the actors up the supply chain? I think, well, there are some opportunities that still need to be explored more, such as Jehovah's Witnesses, for instance.
Thank you. And before we open the room for questions, because we have 5 minutes left, I want to thank all the panelists, Professor Dr. Purtova, Dr. Felix Bieker, and Kristina Michalakaki. So a big round of applause for all the panelists. And then I see we have a microphone, so if anybody has a question, feel free to pose the question and address it directly to one of the panelists. So maybe we can start with the lower row and then go up.
Thanks a lot for the fascinating presentations. I'm Emanuel Bouyakiotis from the European University Institute. And I wanted to ask Professor Purtova, I agree with the determination that a broad scope and intensive compliance is unworkable. So I wanted your thoughts on first the idea of duties of loyalty or information fiduciary, some kind of general principle that is more flexible, or the idea of use regulation that Professor Solov recently suggested, particularly in the context of sensitive data. Thank you.
I'm sorry, could you repeat the last one? The idea of what?
use regulation. We regulate the use of the data, not, yeah.
Oh, yes, I know what you mean. The idea proposed by Daniel Solov still hinges on regulation of data. And I think sort of basically the more signposts you give to the information industry, so first it's regulation of personal data. They will find their way around basically and argue that they're not processing personal data. Then they will say, then the next signpost would be, well, let's regulate the use of any data. Then they will argue they're not using any data. And now basically there are some developments in technology sort of it's not just the use of data, or very often the information harms are sort of inflicted, or the information problems occur, like information technology problems occur, without data leaving anybody's device. Sort of a lot of problems already start at the level of design of software. So for me, the problem is not so much about the use of data, but about computing, which I already mentioned earlier. And then why I argue for sort of regulation of computing, not by introducing a similar sort of regime or to the same level of detail as the GDPR is, but the general principles of computing is, this is based on the empirical regulatory studies, and I cite that article in that in one of the recent publications. Basically, the idea is that the more complex a particular context of regulation is, the more dynamic it is, and the higher the economic stakes, the detailed regulation in this context normally leads to less legal certainty and less legal protection, because the more details you basically give to the industry, they use it not as the limitation of their activities, but the signposts they have to sort of maneuver around to still sort of stick to their business models.
And I think we have room for 1 or 2 more questions. Okay, 2 minutes. So maybe 1 more question in the very last row.
Perhaps because I think this is something that we can discuss further after the end of this panel. But I'm Zoe Cardasiadou from the European Commission. I'm working in DigiJust on data protection. So I would like a bit to tackle this difference between harm and risk, and to make the statement that there is no real difference. If you see harm, because risk, when it is used in the GDPR, is not, it's also again a composite of harm and likelihood to occur. And this you see always throughout when somebody has to do a data breach notification or a DPIA. We are using metrics. The DPAs, they have also developed this kind of tables where you see severity, likelihood of what? Harm, or call it threat. So really, I would like more explanation. Where is a real difference? It might be a difference, though, that the risk in the GDPR is not related to an intended purpose, at least not clearly related, while in the AI Act, there is always the intended purpose. And this is maybe explicable because the AI Act regulates already high-risk systems, not below that. And again, the link to the GDPR. In the DPIA, when we have to consider high risks, again, it is considering the context and purpose of the processing. It's similar to a bit intended purpose in the AI Act. So there are not a lot of differences there, as we might anticipate. And indeed, there is complementarity at the end. After all, this risk notion came a lot, it was also an engineering notion, because in the legal theory we had more harm, which of course can likely occur, has not to be materialized when we speak about harm. Then we speak about damage, if it is materialized. So the real theory, we knew previously harm, and then by combining the likelihood of occurrence, we have created the notion of risk. Thank you.
I would indeed say to take up this discussion after the panel. Not that I want to be impolite, but I heard that they have to close the building fully, so that's why we really had to stick to the time frame. Before everybody stands up and goes, I also want to thank my team at CPDP who helped me for this panel. Laura, Pierre, Isabella, Bilgesu. So thank you for helping me, and yeah, thank you everybody for showing up, and I wish you a great evening.